What's up, everyone? I've got absolutely explosive news that just dropped, and this is going to send shockwaves through every anti-gun state in America. A federal appeals court just handed down a ruling so devastating to carry bans that anti-gun politicians are in full panic mode right now. We're talking about a decision that doesn't just chip away at gun restrictions. It completely annihilates the legal foundation that's been used to justify carry bans across multiple states for decades. The single most important revelation buried in this 87-page ruling is going to change everything you thought you knew about Second Amendment law. And when you hear what these judges discovered by going back to 1328, yes, 1328, medieval English common law, your jaw is going to hit the floor. Hit that subscribe button right now, because this is the kind of breaking Second Amendment news that the why this ruling is historic mainstream media is desperately trying to ignore. And you can't afford to miss what's coming. This isn't your typical incremental court victory, folks. What happened represents the most comprehensive judicial destruction of carry permit schemes in modern American history. For the first time ever, a federal court has declared an entire state's residency-based carry permit system unconstitutional, using a legal framework so airtight that anti-gun states literally have no constitutional defense left. The three-judge panel didn't just strike down one state's carry ban. They established a legal standard that makes virtually every discretionary permit system in America legally indefensible. And they did it using historical evidence that gun control advocates swore didn't exist. Here's what's going to blow your mind. Judge Catherine Polk Fail didn't just cite recent cases like Bruin or Heller. She went back and traced an unbroken line of legal precedent protecting the right to carry arms for self-defense from 1328 through colonial America, the founding era, Reconstruction, and right up to today. The court discovered that colonial America had specific documented protections for travelers carrying arms across territorial boundaries. We're talking about cases from Pennsylvania and Virginia showing that denying carry rights based on residency was considered tyrannical even back then. For decades, over 4.22 million Americans with valid carry permits have been criminalized simply for crossing the border into restrictive states. But that changes today. The judges documented 23 separate what carry ban was eliminated historical examples from 1690 through 1868, showing that government specifically rejected proposals to ban public carry even during times of war, civil unrest, and documented public safety emergencies. But here's the part that's absolutely devastating to the gun control establishment. The court found that in every single instance where historical governments did regulate public carry, they did so through objective shallow systems, never through discretionary, may issue schemes that gave officials the power to deny permits based on subjective judgment. This completely destroys the legal strategy that anti-gun states have been using for decades. What's even more shocking is how this judge connected historical dots that previous courts completely missed. She dug into the original intent regarding interstate travel and the right to bear arms as a universal American right, not a localized privilege. When you hear what she found about the Founding Fathers' view on strangers and travelers, you'll understand why this decision is sending panic through every gun control organization in the country. The judge basically told these states that their sensitive places, designations, and residency requirements are a legal fiction created to bypass the Constitution. She pointed out that if a right is fundamental, it doesn't vanish just because you crossed a river. Over 8.7 million law-abiding Americans living in restrictive states just got handed the legal ammunition they need to challenge every arbitrary carry restriction they've been living under. Let me hit you with some statistics that are going to make your blood boil and prove exactly why this ruling was inevitable. Currently, 8 states still operate may issue or highly restrictive carry permit systems covering approximately 87 million Americans. That's 87 million people whose constitutional rights have been subject to the whims of government bureaucrats who can deny permits for literally any reason they want. Meanwhile, 27 states have constitutional carry and another 15 operate shall issue systems with objective standards covering over 245 million Americans who can legally exercise their Second Amendment rights without begging permission from the government. Here's the kicker that demolishes every gun control argument. New York currently recognizes carry permits from exactly 0 other states. That's right, 0 reciprocity. This is despite 27 states having constitutional carry and 42 states being shall issue. Meanwhile, states like Pennsylvania and Florida recognize permits from 35-plus other states, proving that reciprocity works without creating the bloodbaths that these politicians constantly predict. FBI and CDC data from the past 15 years shows that states with constitutional how the court justified its decision carry have seen violent crime rates drop by an average of 8.2%, while may-issue states have seen increases averaging 4.8% over the same period. We're talking about real-world evidence from millions of people over more than a decade proving that more legal carry equals less crime. But it gets even better. The court cited studies showing that concealed carry permit holders are convicted of felonies at a rate of 0.02%. Here's the part that's really going to shock you. FBI crime statistics show that permit holders from other states commit violent crimes at a rate of 0.03%. That makes them statistically safer than off-duty police officers, more law-abiding than elected officials, and infinitely more law-abiding than the criminals these restrictions were supposedly designed to stop. New York has essentially created a trap where a person with a spotless background check and a legal permit becomes a felon the moment they cross the Hudson. The ruling also exposed something that gun control groups have been hiding for years. In states that transitioned from may-as issue to shall-issue systems, permit denial rates dropped from an average of 67% down to less than 1%, and violent crime didn't increase. In fact, it decreased. New York alone was denying approximately 83% of permit applications in some jurisdictions, effectively turning a constitutional right into a privilege available only to the politically connected, wealthy, or famous. The judges called this exactly what it is: unconstitutional discrimination that creates a two-tiered system of rights based on social status and political favoritism. But wait until you hear about the constitutional dead zones. This is where the case gets really dangerous for the anti-gun lobby. What this ruling exposes goes far beyond just carry permits, folks. It reveals a constitutional crisis that's been brewing for decades, a crisis that threatens the very foundation of American federalism. In her 84-page decision, Judge Fella identified what states most likely to feel the impact legal scholars are calling constitutional dead zones. These are geographic areas where your fundamental rights simply disappear the moment you step across a state line. Think about how insane that is. You don't lose your First Amendment right to speak just because you drove from New Jersey to New York. You don't lose your Fourth Amendment protection against illegal searches just because you're a non-resident. So why has the Second Amendment been treated as a second, as right for over a century? The judge found that these systems violate the Privileges and Immunities Clause of Article 4, Section 2. This is a part of the Constitution most people have never even heard of, but it was specifically designed by the Founding Fathers to prevent exactly what these states have been doing, creating a second-ass citizenship for out-of-state Americans. Here's what's going to blow your mind and why the anti-gun lobby is in a total state of panic. This case isn't just a Second Amendment win, it's a 14th Amendment revolution. The judge ruled that residency requirements create an unconstitutional classification. By treating Americans differently based solely on where they live, the state triggered what lawyers call strict scrutiny. For those who don't know, strict scrutiny is the death sentence for government overreach. Under this legal standard, the government must prove they have a compelling interest and that they're using the least restrictive means possible. Guess what? Gun control laws almost never survive strict scrutiny. By shifting the fight to the Equal Protection Clause, the judge has given us two powerful constitutional weapons instead of one. Even activist judges who hate the Second Amendment find it nearly impossible to dismiss an equal protection claim. If you provide a service or a right to a resident, you cannot legally deny it to a law-abiding non-resident, period. This creates a constitutional framework that's going to be impossible for gun control advocates to overcome, and the how permits and restrictions may change. Brilliant legal architecture hidden in this decision is something most people are completely missing. The court did something unprecedented. They combined three separate constitutional doctrines into one unified test that gun restrictions must pass. And it's a test that almost no gun control law can survive. First, there is the text history and tradition test from Bruin, which requires the government to prove that any gun restriction is consistent with America's historical tradition of firearms regulation. Second, there's the strict scrutiny standard under the Equal Protection Clause, which the court applied because the right to bear arms is a fundamental constitutional right. And third, there's what lawyers call the anti-commandeering doctrine, which prevents states from nullifying federal constitutional rights through local regulation. When you combine all three of these constitutional requirements, you create a legal gauntlet that carry bans simply cannot survive. But here's the real lethal part of the legal strategy used in this ruling. The court used what's called negative historical evidence. In the Bruin decision, the Supreme Court said gun laws must match historical tradition. Usually, the government tries to find some obscure 200-year-old law to justify their modern bans. But Judge Fail turned the tables. She looked at times of civil unrest, colonial wars, and frontier expansion, and found that even in the most dangerous times in American history, the government specifically chose not to restrict the rights of travelers. This creates a new template for our side. We don't just look at what historical governments did, we look at what they refused to do. Since there's zero historical record of residency-based carry bans in the 1700s, the government's legal argument has a 0% chance of survival. What's even more brilliant is how the court handled analogical reasoning. The judges said, you can't just look at whether historical governments regulated guns in some way and claim that justifies any modern regulation. Instead, you have to look at how they regulated, why they regulated, and whether those regulations, law enforcement, and enforcement shifts were comparable in burden to modern restrictions. The court ruled that the government's historical evidence must show not just that some regulation existed, but that it was constitutional at the time, meaning it wasn't subject to legal challenge or widespread resistance. This level of specificity makes it nearly impossible for the government to win because discretionary permit systems are so much more burdensome than anything that existed historically. Here's where this ruling absolutely nukes one of the gun control movement's favorite tactics, and what these judges said about so-called sensitive places is going to send shockwaves through every state legislature that's tried to ban guns in public spaces. After Bruin came down, anti-gun states thought they found a loophole. They started declaring basically everywhere a sensitive place: airports, public transit, parks, restaurants, theaters, hospitals, you name it. Some jurisdictions were literally trying to declare 95% of public space off limits to lawful carry. The court obliterated this strategy with one devastating historical analysis. The judges found that in the founding era and throughout the 19th century, there were exactly 4 categories of places where carry could be historically restricted: legislative assemblies when in session, carouses during proceedings, polling places on election day, and schools. That's it. 4 categories. Everything else was fair game for lawful carry, including churches, markets, public gatherings, government buildings, and even powder magazines. In some cases, what's absolutely shocking is how the court handled the government's argument about public safety. The state claimed that modern public spaces are more crowded and dangerous than historical equivalents, so they need broader sensitive place restrictions. The judges didn't just reject this argument, they flipped it completely around. They said that if anything, modern Americans have more need for self-defense in public spaces, not less. Because unlike colonial towns where everyone knew each other, modern cities are filled with strangers and have higher crime rates. This reasoning is devastating because it means the government's own public safety arguments actually support more carry rights, not fewer. But here's the legal grenade hidden in this section. The court ruled that even in legitimately sensitive places, the government can't impose blanket bans. Instead, they must use the least restrictive means possible, which means things like secure storage options, temporary surrender procedures, or exemptions for permit holders with training. This creates a constitutional requirement that's going to invalidate thousands of gun-free zone laws across the country. Because almost legal gray areas to watch, none of them use the least restrictive means. They just ban guns entirely and call it a day. This ruling doesn't just affect one state. It creates binding precedent in an entire federal circuit covering multiple states. And the legal domino effect is happening faster than anyone anticipated. Within 72 hours of this decision being published, Second Amendment advocacy groups filed 17 new federal lawsuits across 6 different states, all citing this ruling as direct precedent for striking down similar carry restrictions. We're talking about a legal domino effect happening at lightning speed. Lawyers in California, Hawaii, New Jersey, Maryland, Connecticut, and Massachusetts are literally copying Judge Fillela's arguments into their own filings. The judge established what we call horizontal precedent. This means that while a court in California might not be technically bound by this decision, the reasoning is so airtight and so grounded in the Supreme Court's Bruin framework that other judges are likely to follow it to avoid being overturned on appeal. California is facing 5 separate new challenges to its concealed carry permitting system, including one that specifically targets the state's requirement for good moral character, which the court in this case called an unconstitutional vague standard that invites discrimination. And Hawaii's entire May issue system is now being challenged, with lawyers directly copying the successful arguments from this decision, and state attorneys are already signaling they may not even defend the law because this ruling makes their position legally untenable. What's particularly devastating for anti-gun states is that this ruling establishes what legal experts call persuasive authority, meaning even courts that aren't technically bound by this decision are likely to follow its reasoning because the historical analysis is so comprehensive and well-demented. We're already seeing federal judges and other circuits citing this case in preliminary rulings, signaling that they find the constitutional analysis compelling. The constitutional roadmap is finally being completed. The wall around these anti-gun states isn't just cracking, it's being demolished brick by brick. Now, if the legal arguments didn't wake you up, this will. There's an economic earthquake coming that's going to force anti-gun states to reconsider their entire strategy. And it's hitting them where it hurts most, their wallets. Tourism industry analysts estimate that carry-related travel restrictions cost restrictive states a combined $2.2 billion annually in lost tourism revenue, as gun owners increasingly refuse to visit places where they can't exercise their constitutional rights. Reciprocity. What this means for gun owners' related travel restrictions are estimated to cost New York approximately $847 million annually alone. California is losing over $1.2 to $2 billion from visitors who simply refuse to travel there because they cannot exercise their fundamental rights. But here's what's really going to hurt state budgets. The insurance industry is starting to factor Second Amendment litigation risk into their premium calculations for government liability policies. And states with restrictive gun laws are seeing their insurance costs spike by 15 to 30% because insurers know these states are facing inevitable, expensive legal defeats. California alone is projected to spend over $47 million in legal defense costs and attorney fee awards over the next 3 years just defending gun laws that this ruling suggests are constitutionally doomed. Every state with similar laws now faces expensive high-stakes federal litigation. And with this new president, their probability of losing is nearly a 100%. We're talking about millions of dollars in taxpayer money being flushed away by politicians who would rather fight the Constitution than protect their citizens. But it gets even worse for these states. The business relocation impact is even more significant than most people realize. According to recent Chamber of Commerce surveys, 23% of companies now cite Second Amendment restrictions as a primary factor in choosing not to expand into certain states. Site selection consultants report that 31% of companies now consider state-level gun laws when making expansion or relocation decisions, and restrictive gun laws are increasingly viewed as a negative factor, especially for companies trying to attract employees from other states. When a state creates a constitutional dead zone, they aren't just killing rights, they're killing their own economies. Texas and Florida have weaponized this trend in their economic development marketing, explicitly highlighting their strong Second Amendment protections as a business advantage. And it's working. Companies are taking notice. Here's the kicker that's going to accelerate this trend. Federal contractors and businesses with employees who travel across state lines are starting to pressure restrictive states to change their laws because the current patchwork of regulations creates enormous compliance burdens and potential liability exposure. When a company's employees can legally carry in 42 states, but become felons in 8 states, that creates a legal nightmare. The future of 2A rights that businesses are increasingly unwilling to tolerate. This ruling has essentially turned every restrictive gun law into a financial liability that these states can no longer afford to carry. But let's get down to why this matters for you. This victory represents something much bigger than just a carry permit or abstract legal theory. It's a decision that's going to impact your daily life in concrete, tangible ways. If you're one of the millions of Americans living in a restrictive state, this ruling provides the legal framework for challenging virtually every aspect of your state's discriminatory carry laws, from permit requirements to sensitive place restrictions to ammunition regulations. If you're a gun owner who travels for work, vacation, or to visit family, this decision potentially opens up states that have been off limits for decades. For the first time in a generation, you have legal recourse. You're no longer at the mercy of a patchwork of confusing laws that vary from state to state. You now have legal precedent supporting your right to carry across state lines. And while the litigation is still ongoing, the legal momentum is clearly moving in the direction of nationwide reciprocity or recognition of carry rights. The days of becoming a felon simply for crossing a state border with your legally owned firearm are numbered. But here's what's really going to change your daily experience as a gun owner. The psychological shift that's happening among law enforcement and prosecutors in restrictive states is already visible. They're realizing that aggressive enforcement of carry restrictions is going to result in expensive federal civil rights lawsuits that they're likely to lose, which means they're going to be more hesitant to prosecute technical violations by otherwise out-row law-abiding citizens. We're already seeing prosecutors in some jurisdictions quietly declining to pursue charges in cases that would have been slam-dunk prosecutions just a year ago. The psychological impact on anti-gun politicians is already visible. They're realizing that their strategy of creating gun-free zones and residency traps is collapsing under constitutional scrutiny. They're running out of excuses, and more importantly, they're running out of time. For those of you in shall or constitutional carry states, this ruling strengthens your rights even further because it establishes legal principles that protect against future backsliding if political winds shift. The historical analysis in this decision creates constitutional guardrails that are going to be extremely difficult for future legislators to overcome, even if they wanted to restrict carry rights. Your rights are more secure today than they were 48 hours ago. The impact on permitless carry is going to be particularly significant. This ruling's historical analysis shows that the founding era default was constitutional carry, requiring no permit whatsoever for lawful citizens to carry arms in public. This creates powerful ammunition for advocates pushing constitutional carry legislation in the remaining states that still require permits. Behind closed doors, anti-gun politicians and gun control organizations are in absolute crisis mode, and the internal communications that are leaking out reveal a level of panic that the public isn't seeing. Gun control advocacy groups held emergency strategy sessions within hours of this ruling being published, and according to sources familiar with those meetings, the mood was described as devastated because they realize they have no effective legal response to the constitutional framework this court established. State attorneys general in restrictive states are privately telling governors that their carry ban laws are legally indefensible under this new precedent, and they're recommending against appealing because an appeal could result in an even broader ruling that does more damage. What's particularly devastating for the gun control movement is that this ruling validates what millions of gun owners have been saying all along, that most gun control laws are based on politics and fear-mongering rather than constitutional law, historical precedent, or actual public safety evidence. The court didn't just reject the legal arguments, they systematically dismantled them using the government's own historical sources and data, proving that the restrictions were never justified in the first place. This decision validates what we've known all along, that most gun control is based on politics and fear, not on the law or the history of our great nation. The question is no longer if the remaining states will fall, but when. This ruling provides the master key to unlocking the rest of the country. Whether you live in a free state or you're currently behind the lines in a restrictive one, the momentum is now 100% on our side. We're watching the demolition of a century's worth of unconstitutional overreach in real time. This is absolutely incredible news, and I wanted to get it to you as fast as possible. This legal precedent is going to be the hammer that demolishes gun control laws from coast to coast. I want to hear from you down in the comments. Which state do you think is going to be the next to fall? Is it California, Hawaii, New Jersey? Let me know your predictions below. And if you want to stay ahead of every major Second Amendment victory as it happens, make sure you hit that subscribe button and turn on notifications. We're just getting started, and you don't want to miss what's coming next. Thanks for watching. Stay vigilant, stay armed, and I'll see you in the E.